ideally his employment with the current petitioning employer or the current position before the labor cert was submitted. Once that is approved, then you move on to the AOS or the I-485, which is the adjustment of status. This, for most of you that are familiar with, is a whole bunch of forms, the 485, the 765, the I-131. This is where your family and your support, the dependents, join the principal applicant or the employee, and then you file the adjustment of status as a whole, as an entire family. Alternatively, one of the questions in the previous fun facts was that what is the alternative to adjustment of status? The alternative to adjustment status is consular processing. So you can process abroad in any of the consulates around the world, provided you have jurisdiction, and get your green card abroad, your permanent residence abroad. So it could be done in the US. If it's done in the US, it's called the AOS, the adjustment status. If it's done abroad, it's called the consular processing. What are the basic requirements for a labor certification? I just want to run down some of the fundamental stuff, and then we'll get into the new laws, and then I want to definitely leave time for Q&As because I'm expecting a bunch of questions. So requirements. Requirements, basically, after drafting the ad, you will have to conduct what is called a prevailing wage determination. It's a form that you file with the Department of Labor, again, the 9141 form, and then you complete that, and the Department of Labor will tell you for this professional position, hypothetically software engineer applications, for these job duties, for these job requirements, master's plus 1 or 2, bachelor's plus 5, if it's an EB2 position, with these skill sets, located in Cook County, Illinois, how much the prevailing wage will be. So very similar to the H, where you have to go through determining what the prevailing wage is. H, you can just get it on the website. Here, you will actually have to make an application, and unfortunately, what used to be 10 weeks is now close to 12 weeks. Close to 16 weeks, 15 weeks to be precise. So the DOL has really slowed down in its application of determining prevailing wages. Most companies prefer to wait till you get the prevailing wage determination and then proceed with the recruitment. If you're running out of time, you might not have a chance, because if the person is on his 6th year or her 6th year of an age and you really need to file the labor cert, you might not have the luxury, and you do recruitment and prevailing wage simultaneously. Why do employers prefer to do prevailing wage first? It's very intelligent. Supposing you're paying the candidate $60,000, I'm just making this up, and the prevailing wage comes back for those educational requirements, for that location, $100,000. You are not, as an employer, going to match 40,000 difference, for this candidate. But the argument could be that, for an Indian national who might take anywhere between 10 to 12 to, God knows how long, how many years to get his or her green card, are you willing to make the commitment? Because the employer must make the commitment today before the perm is submitted. The employer need not pay the prevailing wage today, but will be held responsible for paying the prevailing wage upon receipt of green card. So for people from other nationalities, it could be as short as 1.5 to 2 years, maximum 2.4, 2.5 months. For Indian nationals, EB3s are currently taking 12 to 13 years. EB2s are taking approximately 8 to 9. So keep that in mind, that you are not on the hook to pay the prevailing wage today, but you are on the hook to make the commitment to pay the prevailing wage today, because the 9089 form that you will need to complete will have the salary that is being offered. Now, if the salary that's being offered is lower than the prevailing wage, you're going to get a perm denial. Moving on, very seldom, I've never, in our practice in 23 years, the alternative wage survey is something, I will tell you, is a very difficult uphill battle that you will have to fight with the DOL. Most employers steer clear. Most employers stick to the OES, where the Department of Labor obtains these prevailing wages from. There was a rule not so long ago, for those of you who might get confused with 100%, probably I think 3 or 4 years ago, you were allowed to match 95%. That has since changed, and whatever the Department of Labor tells you should be the wage, you must, as an employer, match it 100%. Moving on, we've talked about the good faith recruitment in attempting to find qualified American workers. How and what are the different avenues? 2 consecutive Sundays, you'll have to place an ad in a newspaper of the most popular circulation of where the job is located or the headquarters of the company. This will be literally print ads. For us, it would be the Times of India or the Statesman, depending on wherever you're located. In addition to that, you will have to post internal in-house postings. There will be 4 conspicuous locations for 10 business days. In addition to that, you will have to have online job postings in job search websites such as Monster, Career Builder, whatever. Most of the newspapers are aligned to a particular online job search website. You may advertise in a trade journal. You must place what is called a job order. What is a job order? With the state workforce agency, which is basically the Department of Labor of that particular state, you will place the same perm ad again, so that they then advertise this position, and whichever American logs into the job bank, they are also aware of this position and may apply. After the 30 days, so the job order must be posted. Most of everything else is 10 business days. So, within 15 to 16 days, you're good. The job order must be posted for 30 days, and then what is considered to be a quiet period is the period that you will review the resumes that were selected from the job order. Ideally, we suggest within the first few weeks of receiving the resumes, just go ahead and start the recruitment process and review them. But however, by law, it's a 30 plus 30 math as far as the job order is concerned. Typically, a timeline of preparation of perm could be 4 to 6 months. Most importantly, remember, your ads expire in 180 days. So be aware of that deadline, because you pay thousands of dollars for the Sunday ads, because most large cities, they have very expensive, advertising bills. So be careful of the 180-day deadline. Moving on. Drafting of the ad, as I mentioned, is the first step. Then the ad has to be very craftily drafted. It has to be a combination of the job duties and the job requirements. Now, what is the required combination of experience and education? It must be something that the applicant or the beneficiary must have had or would have been able to document before you hit submit on that perm application. Perm positions can be prospective. So the candidate need not be in this particular position that you're advertising for and you're going to file the perm for currently today. It's perfectly legal to be, hypothetically, a computer programmer or a systems analyst today and then prospectively file for a perm position in the software engineer applications position, software developer applications position, okay? Be very careful. We get this on a daily basis for all our perms. Indian degrees that are less than 4 years. We all know the BA, the BScs are 3 years. The Bachelor of Engineering is a slam dunk 4-year degree. If you are going with solely a bachelor's requirement and the person has a BA or a BCom, do not get pressurized into any other categorization but EB3. Clearly, you're required to prove that the foreign national has an equivalent of a US bachelor's degree. A 3-year Indian degree, which, trust me, I know, been there, done that. I personally feel I finished my bachelor's and I went to the US for my master's. I could tell you my bachelor's, in my opinion, was a lot more rigorous than my master's. But however, no matter what you think of what our honors programs are and how, syllabus intensive they are not equivalent to a US bachelor's because they're not 4 years. There's no dispute about that. So just a bachelor's degree, you can get questions, oh, can I combine my 25 years of experience? Because obviously no Indian national will want to be in the EB3 category considering the backlog. However, unfortunately, the straightforward answer is all you have is a bachelor's and it's a 3-year bachelor's, and no matter what the number of experience are, you cannot combine experience and education towards qualifying for the EB2. Be very careful about that. You will, if you get lucky, you will pass the perm with no issues. You will get a denial at the I-140. EB2s can be categorized in 2 ways. There, I do get a lot of pushback because most of our clients are Indian IT companies, or even if they're not Indian owned, a lot of the technology concept of what we do for our applications happen to be Indian professionals. So we also come across the 3+3. So you have a bachelor's and then you have a 3-year MCA or a master's. My advice in a situation like that, it's very risky. If the beneficiary really wants to do it, that's one way to, you need to educate him or her about the risks. And the fact of the matter is, at the I-140 stage, you will need to justify how the 3 years bachelor's equates to a US bachelor's and how the 3 years master's equates to a US master's. So be careful of that combination situation. Moving on, I think we've already touched base of the 3-year Indian bachelor's. Credential evaluation. Before you, or when you start a perm, much before you submit a perm, please, please, please make sure either your attorneys or if you're doing it in-house, conduct what we call a credential evaluation. You will immediately know from a credible source, you will immediately know what the foreign equivalent is, aka the way the USCIS or the DOL understands the degree. This is super important because you cannot start your credential evaluation at the I-140 stage only to realize that your candidate does not have the equivalent of a master's or a bachelor's or whatever it is that you're required in the perm. Because once the perm is submitted and once the perm is approved, it is pretty much set in stone. You cannot change any requirement, you cannot amend any requirement, you can appeal. And if your candidate does not have what you've put down in page 3, item number 11 where the job duties are, page 14 where the job special skills are required, you're out of luck. Your I-140 will get denied. Experience gained at the same employer. You have candidates who have made a tenure of only working for the same employer, both combination of India and the US. So hypothetically, if you have somebody from Wipro who has worked for 6 years at Wipro, Bangalore, India, wherever in India, and then has worked for Wipro US for another 4 years, for example. In a situation like that, you have to be careful of how you document and what you require. So if the person has been in the same position since he or she immigrated to the US, and hypothetically the position is a software engineer or a software developer applications, and you're requiring or you're filing a perm for the same position, the only experience you can require is the experience in India. Although it's the same employer, it's a different tax ID, it's a different entity. So therefore, the experience gained abroad can be required towards this particular requirement for the certification of the perm or the approval of the I-140. However, if the person has no experience from any other employer, is a fresh graduate of a degree from the US, hypothetically speaking, he just has a master's, and after graduation, this is her first job, that's where you get into trouble. So in a situation where the person has no previous experience, the way we work it out is if the person is in a junior position, it's perfectly fine. Then you have to document that the position being offered, like we talked about in the previous slide, which is a prospective position, should be a position that is a distinctly different position and a more senior position. So then we can make a legal argument if we are questioned, hey, guess what? The current position where we are requiring the years of experience that he's gained is a much junior position than the position that was in the perm, page 2, which was being offered, which is basically a distinctly different position. So when it comes to these things, either you go to the head of the team if you do it in-house, or go to your lawyers. They will help you. Applications are subject to automated screening by the DOL. Current processing times of perm cases are approximately 4+ months. This has reduced. It used to take 6 to 7. The law says it should take 45 days. It's never happened in 45 days from the inception of the perm process in 2005. It had gone up to 6 or 7 months. I can share good news with you, it's down to 4 in the last few months. Cases will either get approved, denied, or audited. Or I should say, approved, audited, or denied in that order. If audited, the employer will be directed to show documents. How does that work? Because everything that we've submitted is online. So you are expected to maintain what we call the perm compliance file, very similar to the public access file, okay? So from that perspective, with that as an ultimate requirement, again, we go back to the word compliance. So be very, very, very careful that all the recruitment that you have done, whatever the list of 7, 8, 9 things that you have to do, is documented in this perm compliance file. Because God forbid there's an audit, all you have to do is whip it up and then provide that to the DOL. If they're not happy, by the way, with your documentation, you will then go into what they call supervised recruitment, where, like the good old times, during the RIR, They will tell you where to advertise. They will tell you which, where to, the resumes should be received. They will want the copies of all the resumes. They will basically control the recruitment and supervise it for you. And you're totally accountable to them. Now, I want to go through just the next couple of slides are all about recent decisions that impact Perm. Oh, before I get into that, I forgot to mention in the slide the Kellogg language. I'm sure all of you who have been doing extensive Perms are very well aware of. A lot of Perm applications were being denied in 2009, 2010, 2011 for the omission of the Kellogg language. What is the Kellogg language? In item number 14, you should be make sure the Kellogg language is always included in item number 14, because that was something that they will consider broadening the horizons of the applicants, and then that will ensure that it will not be denied based on that. Moving on to some recent decisions that impact Perm. The Board of Immigration Appeals, Labor Certification Appeals, the matter of semantics, basically they came around that with the decision that the advertising content requirements for ads placed in newspapers of general circulation do not apply to additional forms of recruitment. So they're very strict about the way the language in which you have to publicize in the Sunday paper ads, in your Perm application, in the prevailing wage. So we see a relaxation on the language. It should not, originally we would always advise our clients, oh, you better make sure it mirrors word for word. So you can see a trend in a relaxing that requirement into saying that certain aspects, certain avenues of advertisement does not necessarily need that exact language or uniformity against all Perm recruitment or avenues. I will tell you on a personal or professional basis, I would recommend to you to still keep or maintain it the same. It's less hassle. Why would you want to change it? The salary, mentioning the salary is a different discussion we'll get into. It's not required in every form of recruitment, but just to play it safe, it's the same Perm ad that you've vetted by the applicant, vetted by the HR manager, vetted by his project manager. Just keep it the same in every application. But either way, there are people who do it differently, and this matter of semantics proves that the DOL has relaxed its denial policy if it's not exact in every avenue. Moving on. Matter of cognizant technology, as recently as September, Volcker reversed the 383 Perm denials and held that the employer's failure to inform US workers about COLA was not to be a valid ground for denial. This is very typical in the US. It's not something that, very typical in India. This is not something that US is familiar with. So not including the COLA language in an ad is not a reason for denial. And that's how Volcker has reversed his decision. Another decision, the One Cybertech Inc. decision in Feb of this year, it ruled that the regulations do not compel an employer to state the wage in the SWA job offer. So AKA, when you do the job order with the state workforce agency, you need not state the salary. Prior to this decision, you can see the different alternatives. Competitive depends on, this is also, who would even want to put words like this in an ad, but I guess people do. Competitive salaries depends on experience, negotiable, will discuss with applicant. The more you make it vague, the more you're opening yourself up for trouble. Be crisp in your choice of language, be very clear in what your requirements are. You will have a foolproof slam dunk case. There are a few more that I want to quickly go through. This, as I titled it, is a mixed bag. Some went as a reversal of decision, some as confirming the denial decision. Matter of Infosys, Volcker overturned the denial of a labor certification where the employer had unanticipated work locations, including the possibility of relocation. Matter of CEO Ally, May 2016, Volcker upheld a Perm denial because the employer failed to interview a potentially qualified US worker during the mandatory labor market test. It stated that the employers have a duty to pursue further when a resume raises a reasonable prospect and that a candidate is qualified. I want to stop just for a few seconds to address this. Be very, very, very careful. Other than, of course, a Perm denial, some of us who've been in the business long enough know that a very reputed law firm was even sued by the DOL when it comes to Perm applications. The involvement, let me make certain things very clear. The goal, to reiterate, is to find a qualified U.S. worker. Whether you find it dysfunctional or not doesn't make a difference. That is what you're required to do by law. There are very